Good morning to everybody. Welcome to this law science event. I am Vanessa Villanueva. I'm a JD candidate at the University of Illinois, and I also will be the moderator for this session. Before introducing today's speaker, I would like to introduce briefly the Law Science Project. So this is an academic initiative that is coordinated by a group of JD candidates who share the same belief in legal methodologies, often understood as a discipline distinct from hard science and traditionally consistent in doctrinal and normative analysis. What we want to do with these series of interdisciplinary talks is to show that legal research can be improved and benefit from scientific methodologies that provide systematic ways to approach questions and deliver falsifiable claims. So if you want to learn more about the Law Science Project, please visit our website and join our mailing list. One of the coordinators actually is dropping now the links in the chat. And I also want to bring to your attention the ongoing call that is partnered with WINNER, which is the World Interdisciplinary Network for Institutional Research. We are collaborating as part of the Young Scholars Committee, and this call is directed for doctoral candidates in different disciplines that will receive feedback from senior scholars. The event is going to be online totally. So if you're interested in having more information, please subscribe to the project. So now to continue the session, I would like to introduce the coordinators. We have today Simonson, which is an SJD at Indiana University Moore School of Law and co-founder of this initiative. We have also Patrick Chuntiawan, who is a JD candidate from the law school at the University of Chicago. And unfortunately, he's not here with us today, but one of the coordinators is Daniel Hefke, and he's a JSD candidate at Cornell Law School. And we also have representatives of JSDs and JSP programs at the University of California, Berkeley, and the University of Indiana. So if you're interested in getting involved, we are currently looking for new law science representatives, and you also will find the link in the chat as well. Okay, so continue with today's session, I would like to introduce Katri Nousiainen. She is a lawyer and professional in legal education. She holds an European Master's in Law and Economics, a Master Universitario di Primo Livello, a Master d'Analyse Économique du Droit et des Institutions, and a BA in Law. She is known for her articles and book chapters on commercial contracts and legal design on law and technology, and especially related to quantum technologies. She supports and assists companies and other operators in improving the quality and efficiency of their legal processes, products, and services within the tools and methods of law and technology, innovation, and legal research. Katri is a resident research fellow at Harvard Law School in the program on negotiation, and is also affiliated with the Hanken School of Economics in Finland and the University of Cambridge at the UK. Presently, she is pioneering research projects on the impact and value of legal design in commercial contracting in law and economics framework, as well as law and quantum technologies. And today, she has kindly agreed to give us a talk on a cutting-edge topic, which is the quantum roadmap. So without further ado, Katri, the floor is yours.
Thank you so much, Vanessa. So hi, everyone, and thank you for having me today. So my name is Katri Nousiainen, and I'm about to present you today our recent work on quantum roadmap. So I have been conducting research in quantum computing and law since 2020 spring, and I actually started at UC Berkeley. So I heard that there were people from Berkeley, so go Bears. So I conducted this research at UC Berkeley with 2020-2021, and also at the University of Cambridge, UK, and in France. And currently I'm conducting my research in Cambridge, in Massachusetts, at Harvard Law. And naturally, I would also like to acknowledge my co-author on the quantum roadmap, Dr. Joonas Keskirahkonen from the Harvard Physics Department, who has been giving a valuable insight and who have been my inspiring how would I say, criminals in mind in exploring the field of quantum computing. Unfortunately, Jonas wasn't able to join us here today, but if you're interested in his works, we will have several book chapters coming out sometime this spring or early summer, and I'm more than glad to provide some of his recent works as well if you are more interested in the deep tech of quantum technologies. He's currently working and pioneering his research in quantum chaos. But the work that we'll be discussing today, the work of Quantum Roadmap, I could summarize it briefly that it tends to give a general overview of the quantum computing to law within the framework of law, economics, and society. And in addition of giving this kind of a general introduction to the field, the roadmap introduces a novel approach to quantum computing by discussing it from the legal design context. And what we will be covering in today's presentation, well, we will be discussing some of the implications and applications by employing quantum computing to law. So why lawyers, legal practitioners, or everybody who's working in policy making should have some kind of an understanding of these emerging technologies. Moreover, we will be addressing some of the open legal and ethical questions that we should be aware of and hopefully be proactive. So these are the things, the main points that we will be covering today. I would say that we will also covering these topics through 5 principles of the quantum roadmap, and also within the framework of what are the, I would say, the nearest promises that we are expecting that quantum computing will bring in the legal profession and at the society at large. So we will be focusing with the commercial applications today. So, and the application of quantum computing for these specific industries and fields. So we will be discussing shortly pharmaceutical discoveries, IPR, how does it affect the innovation and discovery processes, what kind of impact it might have on the banking and financial sector, and something that has been already quite a lot of discussed, luckily in academia, the cybersecurity aspects and the quantum safe encryption. We will be also discussing advanced manufacturing. This is kind of nicely connected to other applications that we will be discussing, like climate change and green transitioning. We will shortly also cover security and defense, because as we know, these goods are dual goods, so you can use them for good, but you can also use them for bad behavior, bad employment. So we want to be aware about this dual character of these goods. Last but not the least, we will also cover the quantum computing in the legal design framework. And next, each of these applications will be shortly covered. So as regards pharmaceutical discoveries and general the application within these fields, we're expecting that quantum resources are to make R&D more targeted and precise. And this means that it will probably bring more efficiency to the research projects. Because as we know, pharmaceutical industry, those are high stake projects that they usually engage in. So it requires a lot of scarce resources, a lot of talents, a lot of money, a lot of time in order to come up someday with a drug or vaccine that is eventually selling the market. But as we know, usually those projects and the path before we are ended up with a product that we can sell in the market is usually really lengthy. And many cases, you might end up with dead ends with your discovery processes. So what we are expecting here within the quantum resources is actually to make the R&D processes more efficient. So when we are able to handle larger amounts of data, quantum computing can bring that kind of efficiency that we are maybe able to block out these kind of dead ends at earlier stages in the process and decide to continue our research in another path. So it can save resources, it can save a lot of time, and Resources, I speak here with a wider sense. So the resources can be scarce resources as educated personnel. It can be the money resources. It can be the time. So these kind of savings we are expecting to see within the pharmaceutical discoveries. So generally reducing transaction cost. Moreover, because we are expecting that the discovery process will be accelerated, we are expecting that there will be more IPR claims in the future. Because if we are able to accelerate the discovery process, it's kind of continuous from there that we are probably able to get more resource in the more faster time. So more claims are expected to be there because if we are able to innovate faster, if we are able to accelerate this process faster, we're probably going to get more protected manners in a faster time that currently is the case. And as we are expecting to see that there will be more IPR claims filed in the future, this also can cause how different operators are able to enter the market in the future and how competitive that market will be. Because naturally, this kind of really hugely competitive fields as pharmaceuticals, it is in the best interest of the operators to have an extensive IPR portfolio with them. So the kind of way, who is the fastest, who is the one who is able to gain the most protections for their discoveries and innovations will have more power within the market. So we can see that all these are likely to be highly connected. But as maybe I could add there for the pharmaceuticals, that of course we are expecting that this will bring a lot of advances for the society at large, for the sake that if we are able to bring into the market more drugs or vaccines that can save lives, it can have a huge social-wide impact. And of course, maybe it's also good to underline already here the ethical standing and the ethical open questions that we might face. Because we know that there are some primary causes in the world. We have certain diseases that would greatly be affecting to humankind, how we are able to save lives. So if we have primary cause for certain diseases or certain drugs, maybe these are also things that we want to take into account when we, as lawyers or policymakers, start planning how to regulate this field. So kind of way, not impeding the innovation or development, but kind of way also providing the right and optimal incentives, how we are able to use these technologies for wider good as well, not only for the commercial purposes. And some of you might be aware, like this is also something that has been discussed with penicillin decades ago, like what is the optimal? Should we make all these things available for everyone, or what would be the right protection, or what is the giving the right incentives to still innovate, still having the commercial spare, but at the same time providing companies the protection that they might need in order them to have the right incentives to innovate further. Well, this is highly connected, so the IPR and materials discovery. So here as well, we see that the competitive advantage is for them who actually applied the first. So the quantum enhanced product development, it will definitely further motivate operators to innovate and pursue market dominance or monopoly position. And as regards market dominance and monopoly position, it is notable maybe in here that the practice is quite different in United States and, for instance, within the EU. So the lawyers might be aware of the cases called Microsoft, how it was decided in the United States, which was allowing for companies to pursue monopoly position in the market. Whereas, for instance, in Europe, I would say the approach is quite a different, because for us it's more seen that companies should not have the monopoly position per se, and that is regarded rather bad than a good practice. So here we want to maybe stress the differences between Atlantic and how does actually play in when it comes for the IPR as well. But we're still expecting that there will be extensive IPR portfolios, because definitely it will be a competitive advantage for those who apply it first. But in this regard, it would be helpful probably to ask questions while we are updating our current legal frameworks around the IPR regime, such as that what protection length will provide the right incentives to innovate, but what is the optimal protection? Is it reached by IPR, or could it be something other tools that we would be able to employ? And how we could, as lawyers and policymakers, to assure that innovation and development is not hindered by this kind of a protection that we are currently providing for companies and operators. So these are maybe some questions that we want to bear in mind, that we are able to provide the optimal incentives and not hinder their entry on the market, but not at the same time creating any great barriers or obstacles through the competition when companies and operators are motivated to strengthen their standing in the market by creating market dominance or monopoly position. Well, as regards banking and finance, one possible application of quantum machine learning is financial forecasting and optimization. And quantum computing has provided for promising cases in risk management, and moreover, to allow companies to save in transaction cost. You might have seen some cases where the banking sector has been using these forecasting tools, for instance, within cases whether to give some person a bank loan and in what kind of conditions. And we have seen that in some cases, there is definitely room for more human consideration at large, particularly regarding cases or decisions or actions that will affect and impact a private person or society at large. Like maybe you're aware about the case, I think it was taking place in the US. There were two people who were having more or less similar backgrounds. Both of them were earning more or less same amount of money every year. But the main difference within two persons was to say that they were living in different neighborhoods. So when they were asking the banks for a housing loan, they were giving really different interest rates and really different clauses for their loans. And this was through the fact that how the system was fed with the data, it ended up actually being discriminatory and biased. For instance, by the way, what is the postal code of the area where you live in? And it was using a data that actually did not provide any information on the person's willingness or availability to pay back their loans. And the decisions were crowded with the data that was not actually anything to do with the person's financial standing. So in order us to use this kind of prediction tools within banking and finance, it is definitely important to call for human consideration, especially when it's questions about decisions or actions that will likely affect individuals and their well-being and rights. So this is highly also related to privacy matters. And as we know, like being products of a human design, these kind of financial tools, they are not entirely objective. So in here as well, we are in a good position now to take a precaution how we want to see this kind of forecasting tools being employed in the future. So there is definitely something that we can learn from the past, how these tools have been employed.
Katri, I think Vanessa has her hands up.
Oh,
Yeah.
yes. Let me have you, Vanessa, here.
Yeah, I haven't told you if you want to do the entire presentation and ask, and then going into the Q&A, or can we jump in and ask you questions directly?
How you find it the best? I'm actually indifferent. I think you might get the best overview if I go quickly the presentation, so then we will have plenty of room for discussion.
Okay. Okay, because I wanted you to recap a little bit what is an IPR.
Oh, of course. I'm so sorry. That stands for intellectual property rights. So that usually comprises like a really just the tools like a patents, rights that are immaterial, something that you can protect. And this is actually really nice that you brought this one on the table, because the intellectual property rights and their recognition, for instance, what is their protection, how wide the thresholds are, what is the time length. We actually have quite a lot of variation between, for instance, within the United States and within the European Union. And how does it nicely play in is that when we are talking about, for instance, coding, algorithms, and so we might have a really different kind of protection that is being offered between the different continents. And this is highly connected, how we are able to provide the right incentives, for instance, for commercial operators to go forward with their innovation processes and development. So for them, the IPR, so the intellectual property rights, that is kind of way the crown jewelry. So when they innovate something that has a monetary value, they usually want to seek protection for this. So this could include software. It could include some kind of algorithms. It could include designs, everything that is intellectual property, something that is non-tangible, if you may say. And for us to be able to provide the right incentives, we must understand the environment where these operators are working. So that would maybe answer for the intellectual property rights.
The issue with quantum and IPRs is that pharmaceutical companies develop softwares that are not protectable. That's the issue.
So we have different kind of protection depending in the United States and in the European Union. So that is actually an interesting question, because, for instance, European Union is currently working on the AI Act draft. So we are greatly looking forward what they come up with that. There are certain things that you are able to get protection in the US, but for which, for instance, you're not able to get a protection in Europe. And this affects the way how companies want to, where do they want to locate that? What is the environment, the geographical environment and the legal environment that they feel that they have the most incentives to be at?
Okay, thank you.
You're most welcome. So if I go back for the banking and finance, so we can say that quantum computing, it is casting a shadow on banking, money transfers, and security. And when quantum computers scale up in the future, so this is something that we have all our beliefs in, that this will be the case, then various files encrypted with the current standards will become more insecure. And first option to replace the current encryption protocols with classical ones that are uncrackable even for the quantum computers. Another way is to sort to quantum cryptography protocols. So we have kind of way two tools, two ways that we can go. We can use the current ones, or we can go for the quantum cryptography protocols. So kind of way we can say that we already have the tools to make sure that the information will stay in safety hands, because employing this kind of how would I say, protective measures to protect sensitive information, that is something we have to be already waking up by now, because the advent of quantum computers have already taken place. So this is something that we should have already implied in our procedures or how we work at the workplaces, to make sure that the sensitive classified data that we wish to keep safe for the time to come will be done accordingly within the current encryption protocols, or as regards like another way to do that is to resort for the quantum cryptography protocol. So we have two ways how to approach this matter. And as regards the cybersecurity part, well, the development of the quantum computers challenges to security will be with the RSA standards. So thus, we could say that the ever increasing pressure that we have there to invest in quantum safe cryptographic protocols, it is definitely pressing. So I could say maybe that summa summarum, the quantum safe cybersecurity is of significant importance for the commercial sphere, but also for nation states and non-state actors, because this is something that is not only within nations, like with the individual nations, but rather this is something that will affect the globe at large. And naturally, we don't want to see unwanted international conflicts that can arise from the possibility of unrevealing classified sensitive information. And this could be, for instance, counterintelligence documents, it can be military plans, it can be international crime reports. So every nation, and not even talking about companies as well, they have a lot of data that they wish to secure, that which they wish to have classified also for the years to come. So it's greatly important that companies and public policymakers are fully aware about these challenges that we otherwise might face in the future. Moreover, as we were already covering the IPR regime, something that is also important to cover is the privacy, the data privacy. Maybe you have heard there is this kind of regulation in Europe, the General Data Protection Regulation, the GDPR. It came to force, I think it was, 2016, if I call correctly. And even though it's a regulation within the European Union, but it is such that it can be forced to everyone, more or less, whether you are operating outside of the European Union. But if you are in EU or outside, it is only enough that you are processing personal data of a EU citizen or a EU resident, or offering goods or services for people who are at the EU area. So why this is important when it comes for the quantum technologies is that we must take the precaution also for the security risks that can be caused by quantum computing in here. Because if we know that there is a chance that certain classified information can be hacked, and if we are not taking the precaution to make sure that this doesn't happen to the data that we are trying to protect, what is usually personal data of private individuals, the unobeyance of this regulation, it can come increasingly and crazy costly for the companies, because under this regulation, there are certain calculations how they will calculate the amount of sanctions that a company will be forced to pay in case that they are unsuccessful in compliance within this regulation. And this is also important because it will affect, and it does affect, companies working in the US soils, as long as they are selling goods or processing the data of the European citizens or residents, or just offering goods or services for people who are in the European Union area. So just to avoid any unwanted legal sanctions or court cases, companies and other operators, they should definitely take a precaution for the general data protection regulation sanctions and start planning how they are able to make sure that the data that they are processing is processed in a manner that is according to the safety standards so that it cannot be cracked by the quantum computing. Maybe I could say in this regard as well that because this is a global manner, it is not only within individual states, but as we know, during the nation states time, it was the states who were the ones who were the operators in the public international law, if I may say. But as we know, nowadays, the non-state actors, they have gradually more, I would say, increasing role within the international politics as well. Non-state actors, well, we have non-state actors for good causes, but we have non-state actors for unpleasant causes. Let's say terrorism. We can maybe think about it within that context. So when it comes for the future and what we are expecting from the future, we can not only think that the players within the international arena are only states, but rather we have to understand that there will also be non-state actors. And there are biases when it comes for incentives for different operators to use these emerging technologies. And what I mean by that is that these technologies, these goods, we regard them dual-use goods. So you can use them for good, but you can use them also for evil. Thus, there might be biases within the incentives, for instance, to disclose of having a functional computer, quantum computer. And why I want to bring this in the table is that even though we are eager to learn that, wow, when we will get the really enough functioning quantum computer for us to be able to process further within these technologies, it might be the case that the incentives will not provide us the perfect ground to get that information. Because as we know, when somebody would have enough functioning quantum computer, they would gain quite a lot of advantages by having it. So it might be their best interest to reveal their possible success of actually having enough functioning quantum computer. So this is kind of something that we want to also bear in mind, that we probably won't hear hip hip hooray when somebody has succeeded, because it might be on their best interest not to reveal that for the society at large or the companies at large, whoever is the one who advances the most, because the benefits that they would be able to gain through that success are really high. So we have to bear those biased incentives also all the time in mind while we're thinking about how and in what way we should take precaution for these technologies. Well, as regards advanced manufacturing, well, we are expecting that it will result in new way of innovations in manufacturing. And here are named some of the fruitful arenas that we are seeing the most promising. So here is been spelled out, for instance, product development, design, manufacturing processes, supply chain activities, so how we can actually optimize and reduce maybe some transaction cost, process optimization per se, this would be for decreasing the use of scarce resources, risk modeling, so this is something that we can also use for the forecasting and chemical discovery. These are something that we might benefit, for instance, with the green transitioning that I will shortly discuss. And I will say that here as well, just as discussed before, early pioneers, they will have the competitive advantages. So as much as you're able to get certain innovations under your name, under the protection of your company or so, to kind of expand your IPR, this intellectual property rights portfolio, the more protected your company will be, and the more room it will allow you to continue your path as trying to reach the dominance in the market. So next, we're going to discuss shortly the security and defense, quantum applications on that. Also, we will discuss the green transitioning. And lastly, we will be also covering what does it mean to have a legal design framework within the quantum computing context. Well, this we already discussed a little bit as we were talking about the international arena. Well, I would say that the quantum safe data transfers and storage, it is closely entangled with the security and defense field. And there is actually one really great professor at UC Berkeley who wrote an excellent book on the subject. I think it was published spring 2020. And this book was published by Chris Hugenel, who is the director for the Center of Law and Technology at Berkeley Law. So if you are more interested on how these technologies like quantum technologies, more larger scale, could be implied and applied within the national security aspects, you might be interested to check on his book on this area. So that was from Chris Hugenel. I think it's a really great piece for everyone interested in national defense and how it would apply in the US soil especially. But what comes from here is that there is a definitely need for intergovernmental legal rule framework and surveillance in certain research areas of quantum computing in order us to be able to actually ensure world security. And as we already discussed, these, as they are dual use goods, you can use them for good, you can use them for bad. And naturally, we wish that we will never see them being employed for abusing purposes of these quantum technologies, just as employing it for purposing of producing war materials, for instance. We have seen from the past how it played it in, and let's say that it could have worked a better way. But maybe I would like to stress here that since I'm coming from academia, I'm not coming from the commercial market, as say. Many of the innovations that we have nowadays, they are from academia. So if we think about atom bombs and so, it wasn't the intention of the people to actually innovate something that could be used to use as a warfare materials or so, but it just ended up so. So we kind of need to find the golden balance that we would still let the researchers in academia and in their labs to hopefully be able to explore and use their curiosity for different paths for research and not impede them for finding a new ways of doing their work, but at the same time, finding the boundaries or understanding for the play rules that we need to have in the international arena in order us to be able to actually secure for the world security. So that is kind of a difficult balance maybe to find, where are the limits for researchers to employ their curiosity and investigate and learn from new things, and where is the limit that we see that might be challenging for world security. So these are kind of the open ethical questions and legal questions that we should be trying to read to find some intergovernmental legal rule framework that would be more applicable for the global as a globe. And one solution that we have come up with Joonas Keskirakkonen is the idea that maybe we could establish a legal collaborative framework for mandatory reporting and supervision to ensure that the international peace and security will not be endangered. Maybe I would like to bring your attention to the current state of affairs. I'm a big fan of the United Nations for many aspects, but maybe there is a room for something else as well, because as we know, the United Nations Security Council, who is currently or intends to play as a watchdog to ensure the world security and maintaining the peace and security in the world, the permanent members of the Security Council are the countries who are the war-winning countries. So we are able to see that maybe this setting for mandatory reporting and supervision might not work within the current state of the Security Council. Because as we have there now, the war-winning countries has the veto power, and we have seen from some of the recent events as well, and world events in general, that sometimes condemning is not enough in international relations. So we have seen cases when the current security measures and the Security Council has been toothless and partly I would even say powerless in ensuring international peace and security. So maybe we will need some other new ways of handling this within the emerging technologies, some way that we are able to make a working security framework for the international arena, something that we would be able to agree or at least start the dialogue. What could be those international legal rules that countries would be willing and obeying to apply within their operators? And we also have to acknowledge probably here that yes, these new emerging technologies, they definitely will bring us a lot of advantages, a lot of benefits, but at the same time, they will bring us a lot of responsibilities. And what we want to say within our work is that there are a lot of things that we can learn from the past. We can learn it from the internet. We can learn it from nanotechnologies. We can see some of the analogies, learn from those, and maybe active now as a proactive way before we see these technologies merging in a way that it's actually too late to take a proper precaution and being prepared. Yes, next I would like to shortly discuss the climate change. So we are expecting that quantum computing definitely will bring some efficiencies when it comes for the sustainability practices and green transitioning in general. So we are expecting to see that some of the materials could be produced in a more environmental and sustainable friendly manner. But we also see that quantum computing can influence the technological process that plays crucial role in finding more lasting solutions for economic, but also the environmental challenges. And these could be including like how we are able to decrease consumption of certain products or materials, or how we are able to boost the energy efficiency. And examples of this kind of technologies that can be used in green transition could include, for instance, more sustainable batteries, the manufacturing materials, how we can make them more long-lasting, energy panels that we are able to use, or more vital approach for quantum technologies, such as forecasting tools used for forecasting, for instance, natural catastrophes or disasters. So these are some of the implications that I'm actually personally greatly interested to see how they will play in, because as we know, for instance, in California, they've been suffering a lot of the dryness of the climate, and we have a lot of furnace burns every year, and we know that is super costly, super dangerous, and super unwanted. So maybe also learning and applying the meteorological tools and the forecasting tools together can actually provide us some new information in order for us to take better precaution and finding a better solutions, for instance, to tackle these kind of issues that we are currently facing. And actually, one of my good colleague, he's working with the quantum green transitioning, like within the deep tech, and he is so excited about their recent works here at Harvard, how they are able to see that you are able to create more sustainable ways of creating energy. And they are working, for instance, with the batteries that they're expecting to be greatly more long-lasting, and also within the solar panels. And then this is actually the last application that we will be discussing today. So the last one that I will be discussing today is the quantum computing in the legal design framework, and how legal professionals hopefully are able to employ these technologies in a way that it would be efficient for their work. So we could say that computable contracts, they state the rights and obligations in a machine executable code. And the current bottleneck is the fact that human language contracts are regarded to translate into machine readable form. And for this purpose, it is necessary to establish a standard contract language. And these kind of computable contracts, they could, for instance, bring benefits such as decreasing the information asymmetry, increasing efficiency in processing. It could improve trust because the information is now in a more transparent and traceable form. And it could enable more strategic decision-making through the transparency. So on the legal side, we could say that it is expected that quantum AI can improve the quality of contracting practice and litigation. For instance, in case law, based on precedents, where the judges are making decisions based on earlier decisions that are being ruled, it could, for instance, be utilized to track patterns, to process development, and to foresee probable judicial results or even solutions. So by this, I can mean that since quantum computers are able to trace a huge amount of data, and how do we teach them? So this can bring efficiencies. This is something we expected to see, that they can bring a lot of data in, saying, within the past, this type of cases, for instance, were decided in certain and certain way. It is likely that cases within this and this kind of facts might end up being awarded this and this amount of damages. So it can actually provide a way to utilize the way we can track patterns. So we can say that within the last 10 years, maybe it seems that this kind of cases were decided in this way. So it can provide some kind of a guiding for lawyers and their customers and clients, what kind of forecast their case might actually have if it ends up in the court, for instance. And within this contracting practice, quantum AI, what it can be applied to track processes and practices and to develop these patterns, it might also be used helpful to foresee legal risks. but also opportunities. And thereby, we wish that it will actually improve the quality of contracting, and hopefully it will improve also access to law and access to legal information. But besides of that, it can also work as a risk management tool. But the patterns and the legal solutions, anyways, just as we were talking with the finance and banking sector, they must always be also, I would say, considered within the human side of them in order for us to be able to safeguard that there is no trade biases, and so that it will also take the end user kind of way into the account and the larger framework especially. And this is the case when it's when we are discussing or deciding matters that would have a high impact on individuals, let's say their rights or their obligations even. So we want to also have the humanity there as a backbone. And in order for us to safeguard for this human centricity, one must excite these design methods in the combined field of machine learning, quantum computing, and computable contracts. And this trilogy, it makes quite a nice, I would say, triangle of awareness that I wish that we are able to see that will be used more in the future. So kind of where we can say that legal design can help to generate data sets and design systems from which the machine learning can be more ethically sound. So the way how we provide the data, what kind of data we are providing, how do we build these systems? Because we see contracts also like, it can be a systems of complex system theory kind of way, because we can have contracts also as a blocks if we think about coding them. So as a result, the uses of legal designed language could actually bring comprehensible and hopefully more indiscriminatory user-centric tools that we can apply within the legal profession. So maybe what I would like to conclude in here is that legal profession should harness quantum computing, but also more largely, let's say, quantum technologies to serve better the legal quality, legal certainty, and maybe last but not least, the access to law. And we are, as a people working in law and policy making, in a really best position to hopefully make it happen in the future, taking the precaution now and be aware about these matters. So if I would say our AAA approach is usually having the awareness, analyze what we have, and then taking to action. So that would be our AAA that I think is highly applicable for these new emerging technologies. So thank you so much. Great. So we have today Quantum Day. So happy World Quantum Day for everybody. So I think this was a great day to discuss quantum computing and a little bit largerly quantum technologies. And in case there are any questions that I could answer, I'm more than happy to do my best.
Thank you, Katri, for your kind presentation. I think that so I'm gonna take my moderator privileges now because we don't have the time. I want a clarification on cybersecurity. So you mentioned that one of the case uses for quantum technology, which also I would like you to provide like a lay idea of what is quantum technology. I think that we should start from there. And how is it connected with the calculation of sanctions and legal design by algorithm? So what I understood from your presentation is that the concern here is the unfairness that an automated regulatory environment could bring. Could you elaborate on that?
So the first question was about quantum technologies in the international arena, right?
No, just if you could provide a lay definition of quantum technologies, because I think that we are not, the audience is very varied. We have doctoral history and They are applying other methodologies that are not aware of what is quantum technologies. And I don't think that you have explained what is quantum technology.
That's a good question. These are usually the Jonas's, Keskirakos's. He loves the quantum mechanics 101. So these would usually be his questions, but I'm more than happy to elaborate this a bit further. So kind of where we can say that quantum per se is nothing new. That's something that Jonas always keeps telling me. So we can be using some of the parts like with the quantum LED lights and so I mean, like, it's not totally something new. And maybe it's important to hear to stress as well that when I talk about quantum computers, it is not the idea that these computers would actually somehow make the classical computers obsolete. So we will still have our classical computers. They are really workable for many things that we want to do with the computers, with certain calculations. They're working really great. So the future will not hold that we would not have anymore, for instance, the classical computers. So these are not, like I would say, not competing per se. So we will still have them. Quantum technologies, well, we can use quantum technologies. We have quantum communication, we have quantum sensing, we have quantum metrologies. So there are different ways of using these emerging technologies. Maybe something that I could provide for the person who asked this question. I don't know if you are interested of listening podcasts or if you're more person who likes to read, but we provided 2 nice sources for having a general understanding of these emerging technologies. We were invited for the Berkeley Law and Technology Journal podcast. I think it was roughly a year ago, to discuss about quantum roadmap and these technologies. So maybe that podcast could give you a nice overview of the different kind of technologies that we are seeing, because quantum computing is only one of the technologies, but there are definitely other technologies within the field, within the emerging quantum technologies that we are already using quite lightly. Like, for instance, in Europe, we work a lot with the meteorological aspects, for instance, for the weather forecasting, and those are also ways of employing quantum technologies. But if I would be, because I know that we have only little time, so Vanessa, do you think it would be possible to provide the audience some of the materials that we had earlier? I think there should be maybe a Berkeley podcast, and also what gives a nice overview is the article written for Legal Business World. That is a really short read, and both of them are, well, the podcast is spoken in a way that is definitely understandable for everybody, regardless of your background. And that is the same case for the Legal Business World article, is definitely written lay audience in mind, just to give kind of like an introduction for the field. So maybe we could provide those materials again for the audience.
That has raised a hand, Simon.
Yeah, thank you. I know we only have a little bit time, but yeah, as a tech law scholar, or at least a researcher, it's always interesting to learn, new technologies. And so when it comes to tech law, there's also always the issue about, of course, understanding the technology, which Vanessa was asking about, but then how do you regulate it, right? And then we also encounter the idea of the pace problem, right? It's just too fast, and you introduce a lot of different sectors. So maybe within the limited time, what is the sector that you think will have the potential to employ this, within the fastest pace, in your perspective? And I know this also considers different countries, different government or private sectors, right? But what is your prediction here?
That is a good question. That is a really good question. When I have been discussing this matter with my peers, some of them who are really working with the deep tech and others who are working with the softwares, it seems quite a common answer that before we are able to see something that is fully functioning, fully operating, there would need to be a lot of progress simultaneously within different levels. So that is something kind of way what they are waiting in academia to have that process. But I mean, we are already applying some of the technologies, let's say with the classical computing side. So for instance, these forecasting tools, optimizing tools. So these are already something that we are seeing and what we are expecting to have. So kind of way, we have the understanding of the many of the things, how they should work, but we haven't made sure yet for the states where all the pieces would be enough functioning for us to be on the advanced level. I wish I would be able to tell you, Simon, what is going to be the biggest thing, what is going to be the most promising thing. But I think when you brought on the table the space, the satellites, everything, I think at least these are of crucial importance, because as we know, you can use them for the good, you can use them for the bad, you can have the satellites, and when you have your site up to the sky, we know that we can use these also for self-defense purposes. So I mean, it's difficult to say what is the thing that's going to be running the fastest and the first. I know that there are countries that are greatly succeeding building their own products on this. For instance, you might know companies like IQM. So what they do the little ships. Then we have companies like Quantinuum that used to be Cambridge Quantum before it emerged with Honeywell. So we can see the commercials already, but when we look where do they get their most sales from, it's not yet exactly the products or the things that would be the quantum things yet.
Katri, we have another question from Patrick. Patrick, do you want to?
Yeah, I just have a short clarification question, because the problem you mentioned we encounter sometimes overlap with that machine learning algorithm and something. So do quantum means this quantum qualitatively different from all the terms I mentioned, like algorithms, machine learning, deep learning, or it's just like describing a more a much stronger computing power?
Yes, exactly. That is the thing. So that is why when I was first, I think the first subject that I was discussing was the pharmaceutical industry. So that is kind of way where we expect to see the most of the power to come in, when we are able to process more fast, more bigger amounts of data. And by that, for instance, saying whether some bits ends come faster than currently is the case. So that kind of brings in the efficiencies in there. And no worries, if you have more questions, I'm more than happy to provide my email. And if you have questions for the deep tech, Jonas as my criminals in mind, I would say that he has a way better insight for answering probably like a deep tech technical questions. And he's really happy to share his information. He's also teaching quantum at Harvard Law, Harvard Physics. So, I mean, he's used for a lot of questions. So please do not hesitate to drop a line for me. I'm more than happy to forward for him. Or if there is anything that you would like to learn more about our works or research, or you think that there is something that you would like to bring on, is there something that you would like to bring your input for?
Katri, thank you very much for your presentation. We ran out of time. I would like just to Simon to take the picture now so we can let our participants.
Oh, thank you so much. So all the participants, please turn on your camera and we can take a picture together. Yay, see Montana. And we won. All right, so I'm gonna count 1, 2, 3, and we can take a picture together. 1, 2, 3. I'm gonna take another one. Wait a second. 1, 2, 3. Fantastic. Thank you very much.
Thank you so much.
And see you in 2 weeks for our next presentation on empirical methodologies applied to contract law.